Gary Pick asks me on Quora, when do trademark rights start if you have a free service? Many software apps and online software require years of development before launching and then could be free for a while before generating sales. Are rights based solely on sales transactions? I'm Andrei Answers, the founder of Trademark Factory, and here's my answer to this question. You're not required to make money from your products and services for your brand to be trademarkable. The trademark use that's required in the US and currently Canada and some other countries before your trademark registers or before it's recognized that you have a common law in that brand relies on you having your products and services out there in what's called the usual course of trade and commerce. And it doesn't mean that you have to sell them. It doesn't mean that you have to make money on them. What it means is that they're distributed in what's called the usual course of trade. So if you have a freemium model, it's perfectly okay to claim that brand, that name, or that logo for your brand, for your business. A lot of trademarks are registered for, podcasts. Right? People don't charge for podcasts, but they still value the name. So it's not about you taking money for your product and service. It's about you putting your product or service out there for people to be able to consume on the marketplace. And doing that is sufficient. David Michaels asked me on Quora, why do some IP lawyers think that domain owners are not entitled to offer their .ca, that's for Canada, .ca domains for sale? Well, there's several reasons. The first reason is that .ca domain names, Canadian domain names, are supposed to only be owned by Canadian entities, so Canadian residents, Canadian citizens, Canadian companies, and those who have a Canadian trademark. So if you're a foreign business, but you have a trademark registered in Canada, this is how you can also get a .ca domain name. If you have no connection to Canada, you're not really allowed to own a .ca domain name. So one of the reasons that IP lawyers think that you can't sell your .ca domain name is if the potential buyer has no connection with Canada. You can't register it in the name of a Canadian company and then sell it to somebody who's not, unless they have a Canadian trademark. So that's one reason. The other reason that I'm thinking that they might say that you can't sell is if your domain name is really a copy of somebody else's trademark. So if somehow you manage to register, Microsoft.ca domain name, and then you pick up the phone or send an email and say, hello, we got the .ca name you might be interested in, then you approaching the rightful owner of that trademark that's saying that you've got a domain name that matches their trademark is not a good idea, because Canada has the Canadian version of what's called Uniform Domain Name Resolution Policy, UDRP. So in Canada, it's called CDRP, Canadian Domain Name Resolution Policy. And the whole idea is that if you register a domain name in bad faith, hoping to sell it to the rightful trademark owner, you're not going to have that domain name for long. And there are some borderline situations when you might have a legal interest in the domain name that the trademark owner could not enforce against you until you reach out to them and say, na 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 na, I got your domain name. If you do that, it just shows bad faith on your part, and that domain name can be just taken away from you for free. So these are the two reasons that I can think of. Why else IP lawyers may think that? Well, I don't know. If you have something specific in mind that you think I didn't cover, comment below and I'll be happy to respond to your comment in a follow-up post. David Hamilton asks me on Quora, how do you trademark a slogan? The process for trademarking a slogan is pretty much the same as is the process for trademarking a name or a logo. Here at Trademark Factory, we use our proprietary process. We call it TM's into R's brand protection formula. It has 6 steps. They all start with an F. The first thing you do is you figure out what slogan that you want to trademark, and you finalize that phrase. The second thing you do is you figure out if it's even trademarkable. Usually you don't want to do it yourself. You want to have a trademarking specialist to look into that, do a proper trademark search, and come up with an opinion based on more than just the identical matches that they'll be able to find in the automated software, but actually based on their experience, what other things the trademarks office is going to look at. So second, you figure out if it's trademarkable. The third step is to file your trademark. That's easy. That's why there are so many firms out there that will file your trademark for next to nothing. The fourth step is to fight to get it approved and allowed. But after you file your trademark, several months later, the trademarks office is going to look at your trademark application, and they're either going to say, we love your trademark application, which is great, but doesn't happen very often, or they're going to find something that they don't like about your trademark application, and then it becomes the job of your trademark attorney to make sure that they can satisfy the requirements of the trademark examiner, or maybe even argue with them to make sure that they're convinced to approve and then allow your trademark application. The fifth step is to finalize your registration. So after your trademark is allowed, in many countries you need to take care of post-allowance government fees, or it could be filing statement of use. Again, really depends on the country, and because you didn't specify that, I'm not going to go into this. But sometimes there are formalities after the trademarks office allows your trademark and before it registers it. And the last, sixth step is to follow up, because every 10 years you got to renew your trademark. If your address changes, you need to notify the trademarks office. If your company name changes, it's another reason why you want to notify them. So there's a couple of other things you want to take care of after your trademark registers. So 6 steps. Figure out what you want to trademark, find out if it's trademarkable, file it, fight to get it approved and allowed, finalize to get it registered, and then follow up to make sure it stays registered. It's the same process for slogans, taglines, names, logos, pretty much anything. And from the trademarking perspective, the trademarks office doesn't really care if it's a phrase or if it's a name or logo. They treat it also exactly the same way. Rohit Tamma asks me on Quora, can I trademark a logo in India when a similar trademark is already registered to my competitor in the USA? Really, this depends on 2 things. First is, and I assume the answer to that is no in your question, but the first one is, does the US company have a trademark in India? And they very well could. If they do, of course, you cannot trademark that same brand in India. But again, I assume that when you ask that question, that US company does not have an Indian trademark. And from there, it really boils down to how well known is that US company in India. If it's some obscure name that nobody really knows about in India, they don't have any sales in India, they don't have much of advertising in India, and all they do is they just protect their US market, then in most cases you actually would be able to trademark that brand in India, because trademarks are registered on a per country basis. They are protected on a per country basis unless, like I said, the brand is so well known that it's reasonable to think that everybody, the public, would immediately think of that other brand when they see your products with it. Yeah, so basically you're looking at a situation when it has to be somewhere in between, right? Because really all the big names, like really massive names, they would probably have a trademark in India already. But sometimes they may not be as famous and they haven't necessarily bothered to trademark their brand in India, but if they're heavily in that market and they're well known in the market, you may still have an issue with trying to trademark their brand as your own. Again, there are countries that don't really care about this, about the notoriety of another brand unless it's trademarked. But the good rule of thumb is, look, if you know that they're your competitor, they know you, and you know them, it's just not a good idea. I mean, you may be able to get away with that. You may be able to get away with it for some time. But I don't think it's good business practice. And again, with Trademark Factory, we don't take on anybody. And with, like, for example, with Trademark Factory, we don't work with everybody. So if you came to us and say, you know what, I think there's a good opportunity here. There's this US company. They don't have an Indian trademark. We want to do the same thing and sell the same products and services in India. We turn you down. Because again, I think that, so our job really is not just to take your money and file your trademark. Our job is to make sure that we add value to a legitimate business that's really trying to protect their brand. I mean, if you know my story, I got into the intellectual property industry because of my father, who was a famous composer in Russia, and one day heard his music on the radio advertising Samsung without his permission. So I know what it feels like when somebody steals what you've poured your heart and soul into. And I really strongly believe that those who create something that hadn't existed before deserve to not have it stolen from them. So if you come to us knowingly trying to rip somebody off, we're not going to be the ones to help. John Daniels asks me on Quora, I found a name similar to mine on TESS. It's the US Trademarks Office's trademark search system. Do you think this would be an issue? I don't know. And really, that's why we always tell people, do not do your own trademark searches unless you know how to properly interpret them. Because most business people, they don't really know what to search for, how to search for it, and when they get some results, they don't know how to interpret them. There's a lot more to it than just running a search and trying to see if somebody's got a similar name. What you want to look at, how similar other products and services. You want to look at what the status of that other trademark is. Is it registered? Is it applied for? Is it allowed? Is it canceled? Is it abandoned? Can it be canceled? Can it be... Like, there's so many things that you want to look at. Just because you found a similar name doesn't really mean anything. And if you didn't find an identical name, that also doesn't mean anything. Because there could be similar names that you didn't find. So really, to answer a question, do I think this would be an issue? It could be an issue, but it might not be. Really, like I said, it depends. And what you want to do, if you're serious about building a brand that might have some value in the future is to look into this early on and make sure that you're building your business, you're building your brand on a solid foundation. If you want to do that, most firms would charge you around $300 to run a proper trademark search and come up with an opinion and tell you whether or not it's trademarkable, whether or not it will be an issue, whether you can't even use that name for your products and services, because that's the biggest concern, right? It's not just about, oh, I can't trademark my name, well, I'm just going to keep doing what I do without a trademark. The biggest problem here, the biggest risk is that if the name is too close, you can't even use it. You can't even sell your products and services under that name. So that's why, like I said, this $300 or around that would probably be the best investment you've made in your business. And by the way, if you go with Trademark Factory, the comprehensive trademark search is built in all of our packages. And if it so happens that the brand you came up with is not registrable, you can get all your money back. Burt Hanna asks me a question on Quora. Should you trademark your brand name as soon as you open your business? Well, Burt, how do I answer this? It's almost the same as if you ask, should I get a domain name as soon as I open my business? Should I build a website as soon as I open my business? Should I rent an office as soon as I open my business? Should I hire a secretary as soon as I open my business? Should I start a YouTube channel as soon as I start my business? Should I write a book as soon as I start my business? Should I do this or should I do that? It really all depends. It really all depends on the strategy that you have for your business. It really all depends on the vision that you have for your business and the importance that the brand is going to play in the success of your business. Most successful companies, they trademark their brand either before they launched or shortly after. Is it necessary? No, but can you see a lesson in there? Absolutely. I know I did. I looked at when Coca-Cola filed their trademark, which is the year when they were selling 9 drinks a day. I looked at Airbnb that filed their trademark while the owner was still renting out his own bedroom on Airbnb to pay for the overhead. I looked at Uber that filed their trademark 2 months before they launched. Google and Facebook filed their first trademark the same month when they were launched. So they all did it very early on. They didn't wait to become those massive corporations that they are today, with their brands being worth billions of dollars. They just knew that if they are to be successful with their businesses, their brands would be valuable. So they protected them when it was easy, when nobody really cared about those brands and when they meant nothing except to them. So should you trademark your brand as soon as you open your business? I don't know. But really, my question to you is, why would you spend a minute of your life or $1 out of your pocket building a brand that you don't own? A brand you don't own is a brand that your competitor can copy and you couldn't do anything about it. A brand you don't own is a brand that you cannot monetize. A brand you don't own is a brand that can be taken away from you like this. I mean, look, a brand can easily be the most valuable asset of your business if your business becomes successful. So if you've been running your business for 10 years or 10 minutes, you owe it to your business as the business owner to protect the brand. And protecting the brand, you do it through trademarks. But again, other situations when you don't have to worry about trademarks at the very early days? Absolutely. Absolutely. If the brand doesn't matter, if you can change the brand without any issues at any time, and you're not really building a following for your brand, if people find you because of your personal name, not because of the brand you came up with, do you need to trademark the brand right away? No. Get some traction on the product. If you have a unique product and you don't care about the name, make sure that people care about the product. Then come up with a name, trademark the name, and you have a good business. But if in your early days you're spending your time, money, and energy trying to promote that brand, well, our own tagline is, if it's worth promoting, it's worth protecting, right? If you're putting money out there to make sure that a lot of people know you under that brand, that might be an asset that you want to own so that you don't feel that regret that it would have been so easy to trademark this early on when nobody gave a damn about your brand. And then at some point somebody jumped in and trademarked it and now you can't have it. So don't be the one who's full of that regret and saying, I could have owned this and now I don't. Now, I hope this answers Burt's question. And if you found this useful, if you found it interesting, if you'd like to see more videos like this when I answer questions about trademarks and branding, subscribe now. Make sure you get notified whenever the next video goes live. And if you have a question for me, comment below. I'll read your comments. And if your question has something to do with branding, something to do with trademarks, and has some value to the audience of this channel, I'll be happy to answer your question. And to all my subscribers, I want to say thank you for supporting me. Thank you for sending in your questions. Thank you for your comments. Thank you for your likes. I really, really appreciate you. And I really appreciate your support in helping me grow this channel, because I believe that business owners should care more about their brands. They should care more about the asset that can make it or break it should their business become successful. So by supporting this channel, you're helping me support those business owners who need this information. So again, thanks a lot. If you have a question, comment below. If you haven't subscribed yet, subscribe now. And until then, I'll see you in the next video.